Oh, good Lord, that was fantastic. One car, one sign, one pair of unzip pants. Ladies and gentlemen, I give you my defending cries, we're going federal. Judge Mike laughs, no big dummy and not a chance, not a nudge. Cite some nonsense, Fourth Amendment too, but this circus belongs to one man, Magoo. Crashed into a mobile sign late at night, hair all wild, pants not tight, cops rolling, not sure what's true. Is he drunk and cussed or just plain Magoo? Mr. Magoo.
Mr. McGrath?
Yeah.
Good morning. So we are on the record in case number 266847ST. You're appearing for arraignment purposes this morning. Ms. Mistely is the defense attorney available through the Indigent Defense Counsel who will be assisting you. She has not yet had an opportunity to speak with you. I'm going to place you and Ms. Mistely in a breakout room.
Right.
Before I do that, I do want to verify your phone number. Mr. McGrath, what's your phone number?
My phone number is 355.
Thank you. So I will place you and Miss Mistely in a breakout room, a place where you can have a private conversation with her so that she can go over the issues regarding the arraignment before we continue.
All
Your
right.
screen will ask you to join that breakout room, and when you're done, you'll return to this meeting, please.
Sounds good.
Welcome back.
Thank you.
We are back on the record in case number 266847ST. Ms. Mistely, did you have opportunity to review allegations on the complaint, nature of the offense, and possible maximum penalties with Mr. McGrath?
I did, and we will waive a further reading of the misdemeanor complaint and enter a plea of not guilty. Mr. McGrath will be representing himself for purposes of the pretrial. He knows what document to have with him, and he understands he can later request counsel if need be.
Thank you. So, Mr. McGrath, the pretrial conference in this case is going to be scheduled for March 24th at 9:30 a.m. in person here at the district court.
What day is that out of the week?
Tuesday.
Okay. Sometimes I have university to attend.
I'm sorry?
I said sometimes I have university to attend to and or work, so I just have to make sure that I'm able to attend to its request per professor and or other higher ups in order to convey my potential absence from that day. But that should be it.
So I would suspect that you'd want to prioritize.
It actually gets dumber.
The court has the highest up. A professor can't put you in jail if you fail to appear to a school.
Correct. Yeah. Just to allow them to convey to them that I might be absent that day but yeah.
Thank you. I thought you were saying you might be absent from court.
No.
So, great. March 24th, 9:30 a.m. in person here at the district court. You were not arrested. I'm going to place you on a $1,000 personal recognizance bond, which is.
I mean, they're up in Traverse City. There is not a university in sight.
A PR bond. You don't need to post any money. It's your promise you'll be at every court appearance and that you will abide by the conditions of the bond. Conditions of the bond are that you may not operate a motor vehicle without a valid driver's license, registration, and insurance. And as Ms. Mistely indicated to you, you've not waived your right to be represented by an attorney. So you're welcome to hire your own attorney, or if you would qualify to request the court appoint one for you if you are not comfortable or satisfied with the outcome of that pretrial conference. I do want to verify your mailing address, please, Mr. McGrath. What is your mailing address, sir?
My mailing address is Wildwood Road, Interlochen, Michigan, zip code
Good Lord.
49643.
No.
Thank you. Do you have any questions?
Kind of. I just wanted to ensure that is the information conveyed? Are you able to well, hold on, let me
No, it's blurry.
just are you able to convey the information on the other side of this?
No, sir.
But is that because of your perspective is unable? It's mono perspective, right? There's not information conveyed on both sides. Is that correct?
I don't know what it is that you're holding up.
It's information. It could be pertinent information, but you are in agreement that you're unable to convey the information on the other side.
He drops you are in agreement while trying to sound smart. You just flunked completely.
Is that correct? Because it's not labeled on both sides, correct?
So again, it could be a blank piece of paper on both sides. I'm not sure what you're trying to get at.
I just wanted to make sure that you're unable to discern the contents on the other side of its piece of paper because it's not bidirectional in terms of the conveyance of information. But if its perspective was, i.e., if you were facing the orientation of in which the information was being conveyed, you would be able to discern the information if you were to alter or the information was to be on either both sides or you were facing the proper side in which the information was being conveyed from and not being entrapped from an individual, you would be able to discern the importance of its information on the other side. I just wanted to make sure that you agreed that because of that, you were unable to discern the information on its listed side. I just wanted to make sure that was known. So, but thank you for proving my point. I appreciate that.
Okay, dummy.
Thank you for your appearance this morning, and you are free to leave the meeting.
Thank you.
Bye-bye.
Water, the two water bills, that are 900 something combined. With the 3 months of rent, late fee.
I should mention this. Most of this is Zach over at LawNerdsUnite, and I think Alyssa sent me this part of it.
Fees, water bills, and then support costs were in excess of $12,000. 11, north of 10. I have the total here.
Yes, these are the same knuckleheads that have been on forever. Judge Simpson's attempt to bankrupt yet another landlord. Although this one, I don't really much care because she's annoying too. But he is bent over backwards for this tenant who's awful. That's to catch everyone up to speed, in case you don't know.
Again, we are just seeking a possession judgment. So you'll have an opportunity to satisfy that judgment, or they choose to vacate.
Have you shown the documents too?
I haven't seen not one warning.
All right.
There you go. We're
Just one right there. I can take it.
Oh, of course. I do.
Yeah.
Oh, I thought you had wanted those.
Well, I do, but are those the copies of the same documents or what?
They are the same. Man, sorry. Let's see. This one is the 553. Here, what are we looking at? So this one is the one due in January.
How come I haven't been able to?
Hold on. Stop for a moment. All right. Are they the same documents that she has? They don't look like
One is a picture of a scan, but one is the amount due in January, and the other. January.
Okay, hold on a second. This. Whatever documents you're going to show to the court, show to Ms. Lyman. And then give me the documents you shown to Ms. Lyman.
Okay, man.
Okay, and are these separate?
Yeah, if you look at the dates, Judge, one is the,
All right, look, here, hang on. All right. So have you seen these now?
First time seeing this, I haven't even been able, like, nobody sent me the water bill to even pay it myself. She takes it upon herself to pay it like she did last time. My first time seeing the water bill.
Prior to this, have the water bill been presented to her?
The second one wasn't presented because I just got the second one, but the first one I sent it to her by email. I said that I paid it. But it's second one I just got days ago. So
Every time I was on the portal, I don't see nothing.
through February.
I was trying to recall from the last case, whose name is the water bill supposed to be in? I thought it was supposed to be in your name.
Put it in her name.
That's not what I asked. It's supposed to be in your name, but then you took it and put it in your name.
Thank you.
Yeah, because
So why isn't it in her name? So then she gets billed.
before,
go ahead.
because the township told me that she didn't work out a payment plan and it was on property taxes. Then I put it in my name to make sure I pay it so it doesn't go on property taxes.
Yes, because she can't be trusted. I don't even like this woman, and it makes sense to me.
And that's what I told you last time. It was in my name. And I sent her a copy of the first one and I said I needed payment and didn't hear a response.
The day I was supposed to pay, she switched it out. In her name and she paid it. Told her that I can owe her.
Oh, I remember. But you never put it back and let her put it back in her name.
No, I didn't want to go on the property.
Well, then how's she supposed to comply with the lease?
The
To
lease,
pay it.
the lease says that it can be either in my name or her name. It doesn't specify it has to be in her name.
But how's she supposed to know what she's going to pay?
I sent her an email with the first one, the first bill, and I didn't get a response.
This isn't hard. Why are you acting confused about this, Judge Simpson? It's in their lease. Plus, it's just common sense anyway. She's not trustworthy, so she's keeping the utilities in her name so their property doesn't go to crap. Catch up with the class. She's legally entitled to do so.
Already paid it.
So I was just going to get reimbursed from her.
Oh, the landlord is annoying as hell, but that doesn't mean you just say crazy stuff like that to her.
And I don't know whether this bill is two bills or really one bill. I don't.
Judge, just to, so here's the original. One is the same as the other. But if you look at,
No. Go to the Pittsfield Township website. Go into utilities for stress. Pull me off the amount due.
okay. I think that these are the bills from the township website, but we can try to do that.
You go in there, you put in the address, you come out with the amount there.
This is the address. All right. 425.
Shannon.
Okay. Right. So right. The one that was due in January, she paid to avoid it going on to her property taxes. Just bear with me. And the utility bill info, the current utility bill info from the website, which I'm happy to present, is due now $484.68. Also information that the defendant has access to. Clearly, it's just on the BSA website.
Yeah, because I just told you that.
Well,
I mean, I don't even know why you said that.
I apologize. Wanted the number and
Shut up. Just be quiet. None of this makes any sense to me, counsel. You come in here and you want her to pay this. She's got $6,600 in escrow. When is the other 33 going to be paid? Because I can't keep going through these cases with you two because you two can't seem to deal with each other. So you come here to get rent paid. This is when?
By the end of this month, I will have that.
You know what this is, Judge Simpson? This is entirely your fault for bending over backwards for yet another tenant who doesn't comply with the terms of their lease. Enjoy it. Stew in it. You created it.
Well,
Go ahead.
thank you, Judge. If I may, whatever this court determined the total amount due and owing, she would have 10 days from today. It's already been.
Or whatever time I say, because I have the discretion to extend the redemption date. But thank you for letting me know what my job is.
If the current balance, including late fees and court costs, is $11,529.37.
Ms. Lyman, let me ask you this. When can you come up with $4,929.39?
That'll probably be by the end of this month.
Pardon?
Or still the end of this month. Because I wasn't expecting to be paying the water bill and stuff.
Okay. But,
Able to pay it on my own. Never
Liar.
able to pay it on my own.
okay, that's fine. But, so by the 31st, you can come up with that. Let me ask you this then. By the 27th, what can you come up with? These.
I can't really give estimate. I have to see what my checks come out to.
I need an estimate of what you can come up with.
2,000, at least 2,000.
Pardon? About 2,500 for sure?
Yes.
Okay. Here's what I'm going to do. I'm going to adjourn this matter to March 27th, 2026 at 1 p.m. in person. You need to get $2,500 into.
You're wasting everyone's time. She does not have the money to pay for this lease. Or if she does, she won't do it. This will not be resolved. It will not. They will continue to be in your courtroom.
To escrow by the day before, so I want it by the 26th. And then at that point, I may issue a judgment for the balance, but it will give you additional time out to get things paid.
Okay.
Got it?
Judge, there is, I understand, and just so that is the Friday, March 27th.
Yes.
At what time?
1 p.m.
1 p.m. In the, I would just, if it's possible for the court to consider in the meantime, a supplemental order allowing the plaintiff to have some access to the property because she has something in the action.
Absolutely not.
She's
Want to do that? Quiet. If what you want to do, then file a written motion and I'll deal with it at that point with something Lyman can see. But I'm not going to sit up here with these two women and play this game. Thank you.
I would not put up with that shit. I would not put up with that shit. I would file a motion to get him kicked from this case. I don't know if it would work or not, but he can't be any worse if you're representing a landlord. But I think he's absolutely out of bounds in the way he's treating that attorney. That attorney is an officer of the court. He did nothing. He made no request that was outrageous. You can deny it. That's okay. But just crapping on him for making a very reasonable request is absolutely inappropriate. It's just wrong.
I don't know who wants to go next, but they may not want to.
Your Honor, I can call Mr. Ryan Masano. He's numbers 4 and 5 on the 10 a.m. calendar. As to number 5, this will be resolving today. There's an SOC in the judge's folder. So,
you said Masano?
yes.
Okay.
And Mr. Masano is present with us on Zoom.
Mr. Masano, turn on that camera and microphone, please. Yeah. Good morning, sir.
Good morning.
Looks like there's a stipulated order of continuance here. There we go. All right, I've got the document now. So, Mr. Masano, this is a stipulated order of continuance, an agreement between you and the city prosecutor to continue your case for the next 12 months instead of going to trial. You've agreed that during that 12 months, you're not going to have any criminal law violations and not go to the Pilot Travel Center on 93rd Avenue Southwest. And if you do those things at the end of that 12-month continuance period, the prosecutor will dismiss the charge. Is that the way you understand it?
Yes.
Now, in order to do that, though, you're waiving some rights. First of all, the right to a speedy trial, and instead of that trial happening, there's going to be a 12-month continuance. You're also giving up the right to have a jury trial. So if the prosecutor were to prove that you violated any of those conditions, then you'd have a trial, but to be to the judge only without a jury. And the only evidence in your trial would be the police report submitted by the prosecutor. So you're waiving the right to present legal defenses to the charge, to call any witnesses to testify on your behalf, or to testify yourself. Do you have any questions about that?
I do.
Okay, what questions do you have?
So the question is, if I have an instance of civil disobedience in another state, would that mean that I'm automatically going to be punished without a jury trial?
Is your question if you were to have a criminal law conviction in another state? Is that what that means?
No, if I'm arrested, because I've been arrested 7 times and I've never been convicted of anything. So I'm just wondering if I'm arrested, will that trigger this punishment?
No, not necessarily. The prosecutor would have to prove to the court by.
Does he think he sounds smart? Because that's the stupidest crap I ever heard. No, you don't get sentenced unless you get convicted. And now you've just, I mean, it's Washington, so nothing will happen. But in any normal state, that would just entice the judge to watch you closer to make sure that they're not letting this slip through the cracks.
Preponderance of the evidence that you violated the criminal law before your stipulated order of continuance could be revoked.
Because I would prefer to
I love you, Washington. I love you. I was just making a point.
still have a jury trial if I prefer to be judged by my peers. I don't like the idea of a court just judging me innocent or guilty without a jury trial.
Oh, Pumpkin, you don't like that idea? Too bad. That's kind of the way it is. Courts judge you. That's what happens. You get charged with something, you end up in court, and then there's judges and juries, and they judge you.
Yeah, and that I wanted to be clear with you that is one of the rights you're giving up as part of this kind of an agreement. So if you don't want to give up that right, then you definitely don't want to enter into an agreement like this.
Yeah, I really don't, because I don't like the idea that the courts get to do whatever they like on their own. No, I don't like that at all. And I don't, I should have been arrested in the first place, but okay.
Yeah, you can't be required to waive your right to a jury trial. You can only do that voluntarily. So if you don't want to do that, then I can just set this aside and we won't we won't cancel your jury trial at all. We'll keep your jury trial. So, all right, Mr. Clark, is the city ready to confirm this case for trial then? Or did you have a motion to continue on this
We
case?
did have a motion to continue, Your Honor, on the assigned DPA will not be here. She will be unavailable for the dates of the trial due to training.
All right, so that according.
I don't know what the charge is, but I want this moron to eat a conviction in the worst way. Please, prosecutor, whoever you are, do not drop the ball. Get a conviction on him.
To the declaration attached to the motion, Ms. Will, the deputy prosecutor, is in a training from March 23rd to March 27th and unavailable on April 2nd.
Correct, Your Honor.
Okay. Ms. Milne, do you have a position on the city's request for a continuance?
I have no objection to that motion for a continuance, Your Honor. In fact, I myself am going to be out of town for a training on those jury trial dates.
All right, well, both of those are certainly a sufficient basis for cause. So,
yeah, you know he is.
Avoid that date. So our current trial date is March 25th. Schedule after that. All right, we can reschedule this trial to April 15th and have further confirmation on April 3rd. So Mr. Massano, I'm granting the motion to continue by the prosecutor because there's a good reason for it. And we're going to have your trial instead on April 15th. And your trial confirmation will be on April 3rd.
Okay.
Stay in touch with Ms. Milne and she'll let you know if there are any changes to any of that.
Very good.
All right. Thank you, sir.
Thank you.
Your Honor, at this time I will defer to other counsel.
Okay. All right.
This is a matter of LaShonda Haynes versus David James, case number 26-00204-PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court today on petitioner
It's also being mocked on Law Talk with Mike.
Miss Haynes' request to for an order to show cause that Mr. James be held in contempt of court for violations of the PPO. And it appears that I do have Miss Haynes here, but not Mr. James, even though we mailed him notice of the date of today's hearing. So I guess I will take some testimony from you at this time, Ms. Haynes, and then I can decide whether or not we're going to try once more to get him in here or if I'm just going to have to issue a warrant. So if you'd please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
Very good. Thank you. And would you state and spell your name for the record, please?
My name is LaShonda, Lishanda, Haynes, Haynes.
Very good. And you are the petitioner in a protective order against a Mr. David Paul James. Is his last known address, as far as you know, Bradford Street?
That's correct. Yes.
Okay. Well, that's where we sent the notice of today's hearing to. And you're, I did review the posting that you are pointing to as the basis for the violation. And I do note that was from this number ending in 4757. Do you know that to be Miss James, Mr. James?
That is Mr. James's number, yes.
Okay. And my understanding is this all stemmed out of some beef that started at work and kind of escalated or it got worse after he got fired, something like that?
Well, he and I never had any issues here.
Okay.
Until after he left. And I guess a week after he left, the text messages started coming because I wasn't even the one that fired him.
Yeah.
My general manager fired him. And a week later, he just started sending text messages to my employees with those statements. And so, and then, you know, the drive-bys up here. And I was shocked by the language in those messages because he and I never had an issue.
Yeah. Yeah. No, it seems like he's really flying off the handle there. And you said he has also been driving by your residence or the business?
The job. Yeah.
Okay. And when he does that, does he make threatening gestures or do anything additional like that?
No, he just drives by.
Okay, just to look at the place or for
Yeah.
some reason. Has he sent anything to you since after this post that you sent me? It looks like from January 15th of 2026. Has he posted anything more recently?
Well, he sent a total of 2.
Okay. Yeah, one was the one that you sent with your application for the PPP.
Yes. And
Okay.
then after he was served, he
still sent another one.
Yes.
Yeah, no, that's not good. Well, a couple of thoughts I have. You know, I could notice the hearing again, but I'll bet you if I do that, he's still not going to show up for it. I can issue a bench warrant for him. That'll force him, you know, if he has law enforcement contact, which he might, you know, then he'd get picked up. And, you know, usually what I do is I hold him in jail for an overnight, give him a lecture on watching out for the PPO and showing up for their hearings, and then let him go on a low bond after something like this. You know, sometimes I remind them they're not to have weapons and stuff of that nature. And then, you know, and then I would set another hearing, you know, with, you know, clear instructions for him that he has to show up for it. Now, from your perspective, the risk of that is that it kind of fans the flames on the situation, and things get worse because, you know, he blames you for everything that's happening. So I guess I'd throw the ball into your court. The other option is I can just set another hearing. We can set the notice for him and see if anything else happens. And if this thing dies out, you know, and he never shows up, and we can always issue the bench warrant. You know, if I set the hearing in a month, I can always issue a bench warrant then, you know, based on the fact that he didn't show up then twice. So we do have a number of options, I guess. Since it's you that's feeling like you're at risk, what would you prefer?
I would prefer he did jail time.
Okay.
This is not his first stalking charge. From what I understand, he was involved in an incident like a year and a half ago.
Okay.
So
he's got a history.
it's a pattern, yes.
All right. Yeah, okay. No, that's not a problem since he didn't show up and he did have notice. I will issue a bench warrant for him based on his failure to appear today in court, and then I will try to get him where he's supposed to be the next time. And of course, if he does show up or drive past work, you can call law enforcement and say, hey, he's within my sight and he's not supposed to be. And I think there's a bench warrant out from Judge Rossi, and that may or may not get him picked up. You know, it just depends on how law enforcement, their level of busyness and how interested they are in him. So, but I'll issue the bench warrant.
Okay.
All right. Pleasure to meet you, ma'am. And
Me too.
sorry you've been victimized by this whole situation.
Yeah, me too. Me too. Thank you so
Very
much.
good.
All right.
You're very welcome. Hope you have a great rest of the day.
I will.
Barnes and Barnes versus Alana King.
Ellis Friedman for the plaintiff, Your Honor.
Miss King? Oh, you're muted.
Hi, I am, yep, I'm here present.
All right. And Mr. Friedman, did you get her answer?
I did.
All right. All right, so where do we want to head from here?
I'd like to ask for a hearing at your earliest convenience, and I'd like to ask for escrow.
How much is monthly rent?
1095.
So give me, I'm at the 50, give me 50% of
I'm sorry, say it again.
50% of 1095, which is 550.
He says.
All right. What I'm going to do is I am going to order escrow in this case, ma'am. You're going to need to deposit with the court $547.50. That has to be in cash deposited into escrow. That's for the prorated amount for the month of March. And then $1,095 each month will have to be deposited with court on the date that your rent is ordinarily due. You understand that, ma'am?
I do. I have a question.
Yes.
I'm currently waiting on a commitment letter for the full balance remaining on the ledger. And I just haven't received it yet. So I'm wondering, like, if this agency pays this and I get this emergency funding through this provisions program, which I've been working toward, how would I then what happens? I've been working with legal services and Terrence Crowell at DHS for quite some time trying to get this rent paid and up to date. I don't have a way to withdraw $547. I have $500 coming to me on a child support card. But that being said, I don't believe I can use that at an ATM and just make a withdrawal for any cash.
All right. Well, if it comes through, let me ask you this, ma'am. I see your answer here. Are there repairs that are needed to be done?
Yeah, since moving in with the move-in checklist, I have made several maintenance requests for the windows. I have a 1-year-old, 1.5-year-old, and the windows are pretty low to ground level, but they bow out. I can't open them. When I open them, they completely lift out and away from the tree.
Right, I see that.
Yeah.
Okay.
I just want to make it clear that we have responded promptly and timely and multiple times to any written requests that she makes. She's been very difficult to tie down in terms of getting into her unit. We vehemently dispute the allegations in her answer. This client is maintenance centric, not maintenance avoidance, and we're not. I'm not going. I'll be happy to litigate it in a hearing, but not. I'm not going to have her disparage Barnes and Barnes. Just
no, I got that. I'm just trying to figure out. My real question was this done for the purposes of repairs that weren't being done, or for, I guess, lack of a better term, trying to get time to get the commitment letter? That's where I was going with my question.
Thank you, Ron.
So, ma'am,
I mean, my bathtub doesn't hold water, so I have made.
Have you submitted that to them in writing, ma'am?
Yes, I have. And then I had a cyber attack happen on Christmas Eve after being terminated from my job.
Oh, please.
Which was an unlawful termination after I had an ADA accommodation approved. And this was a termination due to employer discrimination and then retaliation.
And then aliens came and probed me, and then I got knocked over by heavy wind.
The cyber attack, I lost access to all of my bank accounts, all of my personal checking.
Second, ma'am. Does any of that have to do with Barnes and Barnes? You weren't
Yes, that is
employed.
that is why I was not able to make my rent payments timely. I had a 401k I was expected to have deposited into my account, but my accounts were hacked. And then I had fraudulent charges that I had to dispute, and then identity to go in and verify after identity theft.
Ma'am, listen to me. Were you employed by Barnes and Barnes?
No.
Okay. So when I asked, did it have anything to do with Barnes and Barnes? You're not claiming they're responsible for the cyber attack or for the termination from your work or anything. It's just that you run into this difficulty. The difficulty that you've run into with rent right now is as a manifestation of that employment issue.
Yes.
Right?
Correct.
Okay. All right.
My ledger is also still inaccurate. It states that I am locked currently into the 2026-2027 lease when I log into AppFolio. However, it's the 2025 to 2026 lease that I should be tied into, where the rent is $1,095. That has been confusing and has created a lot of financial strain when I have been paying $11.95 for 7 months.
So, all right. I'm going to set this for a final settlement conference. I don't know that the issues that I would have to address here are so significant that we can't do it at that point. I can do, will the 17th work for the parties of this month? Otherwise, I may not have anything till April 14th.
On the 17th, I'll be in the air.
Okay. I'll set it for April 14th. 2026 at 9 a.m. That is for a final settlement conference. Both parties are required to be present in person. Okay, thank you.
Did you order escrow, Your Honor?
I did order escrow. I'm ordering escrow that would need to be paid for the month of March. The prorated amount is $547.50. The monthly rent of $1,095 would need to be paid the first of the month on the date that rent is ordinarily due. Thank you. Peninsula Place versus Promise Johnson. I think I saw her. Okay. Hello, what's your name?
My name is LaToya Terry.
Okay. And do you reside with Promise or?
I am Promise's mother, and I was the one who co-signed for her. She is in class today. And so, yeah. So, yeah, she called the Bank of Mom We Trust. So that's why. And I love you. And I was like, oh, if I got to go to court, I'd rather be in the court with him. So I'm okay.
I presume you're talking to Judge Simpson and not me.
Yeah. I thought you were talking about Mr. Vicente. I didn't know. All right.
I am a fan.
Well, thank you. Okay. So what is plaintiff's claim?
Your Honor, the balance on this account is $2,262.23 through the month of March.
All right. Miss Terry, how are we going to get this paid?
Yeah, so upon my daughter letting me know that she was in crises, I did pay half the balance. And I think that the kids have been able to operate under the previous manage in a way that I just don't even understand, but I'm not even going to try to figure it out. But I did, me and my daughter discussed this. She understands how she's going to move forward. I am going to pay the balance for her. I have no problem with her showing up to court next Friday on the 20th in person, because I will not have the balance paid by then, but I will pay it at the end of the month. And so she can come to court.
Okay. All right.
But I will pay her balance moving forward. And I'm just going to set it up on auto pay. She's a good kid. She's a good student, just young, learning first place. So
where is she in school?
Pay her tuition. She is a biology major, minoring in botany. And so she's at Washington, but she's transferring back over to Eastern. So she's a good kid. Just I think the previous management just kind of let these kids operate if that make a mistake. And I'm hearing a lot of that on this Zoom call. So yeah, but I got it. I'm just gonna kind of handle it on the back end, and she will pay her rent through the summer as her default punishment.
Aw, sweet mom. Just taking a hit for a daughter, but it's cute.
You know,
and this is delaying her in a new car. So
I almost feel sorry for Promise because Promise is going to be paying for this for a while.
Yeah,
In one way or another.
in a car for a couple months. So she's supposed to get a new car, and her car went down. And guess what? That won't be happening.
Yeah. Wow. Poor Promise. Anyway.
And so she's gonna talk to you, Holly. I think she already talked to you. And so she'll talk to you, figure out the payment plan just for purposes of learning, but I am gonna pay the bill at the beginning.
I gotcha. And I'll tell you what, I have to appreciate that. I really do. It's gonna get paid, but you're right. They have to learn their lesson, right?
Yeah.
In some
I have no urgency to not keep her from going to court Friday.
Okay. Then I'm going to set this March 20th, 2026, 12 o'clock. You tell her whatever you tell her. Tell her I'm mad.
Yeah.
And then that way she'll be terrified.
Yeah. Her older sister was like, Mom is busy. You need to tell her what's going on. Da da da. Like, so, but she like I said, she's just a good kid. She's just learning real quick, and she's fine. But I think a lot of it is the previous apartment folks kind of just let them pay whenever they want, like pay whenever. Yeah.
Tell her that Judge Simpson has issued a warrant.
Wow.
Yeah. So yeah.
Boy, Visconti's really going for the juggler. All right. All right. Okay, man. We'll see her next week at 12 noon on the 20th.
I give Mom credit for leaving the court appearance there for her. The kid should be inconvenienced and embarrassed a little bit to grow up. Nothing bad's going to happen, but that's a good play. That's good parenting.
I will let her know.
I've got a daughter who's a senior in high school, so I can relate.
Yeah, it ain't. Yeah. I'm not really even that mad about it. I got her. I mean, I got her back. That ain't no issue. It's just that they got lax with this last company, and it turns it. One thing that's small turns big if you don't deal with it, and that's where we kind of are right now.
That's it. Well, your daughter's blessed to have somebody backing her like you. So we'll see her next week. All right. You take care.
Bye-bye.
Bye-bye.
Were you ready on Leonard Smith?
Yeah.
All right, lines 33 and 75. Leonard Smith, he's on Zoom.
Watch out. This is the other judge in Boone County. This is Zach's fault. They don't play around out there.
Good morning, Yana. Mr. Smith, good morning. Attorney Wade's here in open court, stayed by Attorney Shadden. In addition to the petition to vacate supervision and the already pending driving after, we have a new drive after in 26 MT 189. I will waive reading of the charges, possible penalties. I'll enter a plea of not guilty. I will extend the appointment of the public defender's office to that case. Now, Mr. Leonard, where are you currently? What state?
I'm in Illinois.
Okay. All right, because there was some discussion. So the state filed what's called a petition to revoke release because of your new charge. So are you still on Liverpool Drive in Poplar Grove?
Yes.
Okay. I thought he was in Florida.
That's Tavion.
Oh, that's Tavion. Okay. All right. So here's the deal. You are on supervision for a driving on a revoked license. There's a petition pending based on not doing 200 hours of public service work and the new charge. Now you've been on release. You've been on. Okay, yeah. Let me finish.
Okay.
You're on release for a new driving on revoked license. One of the conditions of your release is to not violate any statute or ordinance of any jurisdiction. Now we have a new driving on a revoked license. Under the statute, either on my motion or at the state's request, I can revoke your release. So are we?
I finished my public service work, and the probation office, they should have all that information.
Right. No, I get that. But if your driving privileges aren't valid, you cannot drive. And now this is the third time, the third thing before me. So yeah, the issue is not the public service work. The issue is that you keep driving when you're not allowed to. So we're going to proceed to a hearing this morning. I'll defer to the state.
Andrew, what are you doing? Don't you have to get ready for your 5K tomorrow? Thank you.
Well, first, let me ask Attorney Wade, do you acknowledge receipt of the petition to revoke release? Okay. State any additional proffers you wish to make or any testimony or evidence you wish to present.
No, Your Honor, the state stands on its written petition.
Okay, before I hear argument, Attorney Wade, any testimony or evidence you wish to present or any additional proffers you wish to make?
I would like to ask my client.
Sure. Mr. Smith, if you could raise your right hand to be sworn in. Sir, do you solemnly swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. Attorney Wade, you may inquire.
Mr. Smith, if you were ordered to turn in your license plates, is that something that you would be willing to do?
Yes.
Questions?
Any questions based on that?
And did you have a driver's license to present when you were pulled over on these charges?
So I'll sustain the objection. I don't want to get into the facts of the case. He's got a Fifth Amendment right. This is just on the issue of whether any conditions or combination of conditions can mitigate him picking up a new Class A or greater offense.
Yeah. I guess I was trying to establish that him turning in his license wouldn't prevent.
No, license plates. License plates.
I don't think.
Okay, I'll hear argument.
Your Honor, we would ask that instead of any type of remand, that defendant be ordered to turn in his license plates, which is one of the options under the statute. He has shown good faith in completing prior public service work, though we do acknowledge he has picked up, another ticket. But we would be asking for that relief.
State.
The state, in its original case, 22MT252 was seeking 60 days in jail. It is not what he ended up sentenced to. But he wasn't able to successfully complete his court supervision. Which is why not only are we seeking to have him resentenced on 22MT252 to enforce the jail that we were originally seeking,
We also believe that this new pending charge, we would be asking for jail time on this as well. So we're asking for him to be remanded, pending further disposition, because that would be the sentence I'm receiving.
Okay. All right, Mr. Smith, under the statute, among the standard conditions of release, once you are either arrested or issued citations for misdemeanor or greater offenses, which these qualify for, Class A or greater offenses, among the standard conditions is to not violate any statute or ordinance of any jurisdiction. I'm sorry?
Yeah, I got a quick question for you.
Who's talking? Okay. All right. So, Mr. Smith, you're on supervision for driving on a revoked license. So obviously you know you're revoked. You then pick up new charges pending for a number of months, and now we have a new charge. I have reviewed whether any conditions or combination of conditions can mitigate the risk of you committing a new Class A or greater offense. I don't see it. I have considered your attorney's suggestion of turning in your plates, but in all three infractions, in the 2022 case, the 2025 case, and now the 2026 case, according to the citations, they involve different vehicles. So you turning in license plates, to me, doesn't satisfy. I'm not satisfied that that's going to keep you from driving. I have no choice. I don't want to.
It would.
A courteous, very nice guy, but under the statute, I have no choice. I'm going to grant the state's petition to revoke release. You and your attorney certainly have a right to disagree with that. You can file a motion for relief at any time during the pendency of the case. Although I will reconsider your detention at each subsequent court date, I'm going to draft the revocation order and issue a warrant commensurate with that. I'm going to set a status date of next Friday at 9 a.m.
Well, this is out in the sticks, you know. This is Boone County. This isn't Cook County. This isn't DuPage County. This is out there. They're not going to mess around.
You will be ordered to surrender yourself to the Boone County Jail as soon as possible.
You on the court date?
I'm sorry?
The rest of the state is quite conservative. It's just there are no people in it, so they're politically irrelevant.
You said on the court date?
No, as soon as possible.
And okay. And how long is the sentence for?
There's no sentence. I haven't sentenced you to anything. There isn't a negotiated plea agreement. I'm ordering you to surrender yourself to the Boone County Jail as soon as possible.
Okay.
Otherwise, they're going to come to your house to come get you.
Okay.
And then you'll be back before me next Friday at 9 a.m., if not sooner. I don't know if anything's going to happen or what agreement or sentence there's going to be. Right now, under the statute, though, I'm revoking your release, and then we'll take it from there.
Okay.
All right. So, okay.
Meanwhile, this judge isn't trying to be difficult. He's just looking at he's looking at the statute and saying, we've got a violation. I got to revoke. Period. End of statement. This isn't an emotional thing for him. He looks at it and says, the way I read it, my hands are tied. This is what we're doing.
All right. So we'll see you next Friday, if not sooner.
Okay. Thank you.
All right. Thank you.
Bye.
All right. We got one more late arrival.
All right, Ms. Denton, how are you feeling today?
It's short, but I feel like it's going to be a good way to close this happy hour out.
Tired.
Tired? Do you know where you are, Miss Denton? I'm sorry?
When I was on the street when I have a lot of money.
Okay. Do you know where you are, Miss Denton? Do you know where you are?
Randall County.
That's right. You're the right. Do you know what year it is, Miss Denton?
She's proud of her.
What year it is?
2026.
Okay. Who's the president of the United States?
Trump.
Okay. All right. Well, Miss Denton, you have from March 12th, 2026, a public
Look at that. She got the standard orientation questions. I'm shocked, actually.
intoxication. The fine range on this is $1 up to $500 plus your court costs. On this violation, Ms. Smith Denton, would you like time to hire a lawyer?
Do I need to? I don't know.
It's up to you. You can pick.
No.
Okay. Would you like to have a trial by a judge or by a jury, ma'am?
No, I don't think you need a lawyer. I mean, you aced the orientation question quiz. I think you got this, girl.
No.
Okay. How do you want to plead? So sorry. On the public intoxication? Okay. Sir, I know you want to help her, but you're in jail, so you're really not in a good position to give anybody legal advice. Ironically, right? So, Miss Smith Denton, it needs to be completely your decision, okay? Do you want to plead not guilty, guilty, or no contest?
Okay, so it was a PI, you say?
Yes, a public intoxication.
I'm gonna say no. I wasn't drinking, so not guilty.
Okay, well, they think you were high on narcotics. So
I wasn't, no.
you weren't? Okay. All right. So I'm going to set a bond.
I don't know where they got that idea. She's getting railroaded, clearly.
We're going to do a $500 cash or surety bond. I'm going to add you, and if you're not out, I'm going to see you tomorrow. Okay?
Okay, well,
All right. Thank you, ma'am.
Can you give me a PR bond? No?
No,
Because I don't have money to bond out. You're not gonna give me money to bond out. Okay, thank you.
Thank you, ma'am. Okay, Millie, add to video arraignment on 3/14.
Yes, ma'am.
If not bond.
There you have it. A perfect closer, and a good way for me to remind you to behave yourselves because I'm not bailing you out. I'm not doing it. I'm here. I'm sober as a deacon. I could, but I'm not going to. Thanks for coming out. I appreciate it.